Nobody listen, where's the, I'm sorry, there it is.
There it is. Oh, good afternoon, everyone. Oh, my hair is doing all kinds of things. We are here to discuss and hopefully move House Bill 336. There are some changes to what we presented this morning. And they have been emailed out to you all. Hopefully you have checked your email. And Claire is going to explain the amendment. But let me just say that the big change is that the district court commissioner would issue a summons. Thank you. And not an arrest warrant initially. So listen up, and Claire will go over the amendments. Thank you, Claire.
So the bill as amended creates a new procedure for the issuance of criminal summonses and arrest warrants by the district court based on an application for statement of charges submitted by an individual who is not a police officer or a state's attorney. On review of such an application, a district court commissioner may issue a summons if the commissioner determines that there is probable cause that the defendant committed the offense or offenses charged in the charging document. The commissioner may not issue an arrest warrant and must refer a summons issued under the previous provision to the state's attorney's office for review and prompt determination of whether a request for an arrest warrant shall be made if the commissioner finds that there is probable cause to believe that the defendant poses a danger to another person or to the community. On receipt of a summons forwarded for review under that previous provision, the state's attorney shall review the case as soon as practicable, but no later than within 72 hours to determine whether to request that a judge of the district court or circuit court issue an arrest warrant. On a finding of good cause, a judge may convert a summons to an arrest warrant, and the district court must provide a victim of crime with access to information regarding whether an arrest warrant has been issued in response to an application for a statement of charges filed by the victim. And then we have the same reporting requirement that was in the amendment earlier today, but one item has been added. Sorry, that this might not have made it onto the reprint, but the item is, do you have that on your reprint?
I don't have it. No.
Sorry. There's a request to add for each arrest warrant issued the final disposition of the case.
Is it number 2? Are you
Three?
looking at?
Should be number 3.
Oh, I don't have 3. I have, no, it just ends at 2.
Oh.
You see B3? Yep. Oh, I don't have B3. Okay. All right.
Sorry about that, but it's supposed to say all of the other stuff, and then for each arrest warrant issued, item number 3, the final disposition of the case.
Okay.
And then, again, the amendment restores current law relating to the crime of making a false statement to the government.
Okay, I'll give everybody time to absorb and think it through. course. Delegate Taylor.
Do I need, I'm not really sure what the difference is in the summons versus.
An arrest warrant?
Correct. I mean, I'm sure they're very different, but just,
A summons is still a charge, but it just says you have, you have to come in. An arrest warrant is, they take you in.
oh,
Yeah.
okay. And but it's still on your record as well.
Yes, it's still in your record, and it is still expungible if the state's attorney decides not to go forward.
Thank you.
Sure, Delegate Moon.
Thank you, Madam Chair. And I don't know who I'm even directing this to, but I just have sort of more general questions about what the world looks like now and what the world will look like tomorrow with these changes. And I guess it's only as to the scenario of a person in a small town in rural Maryland on the weekend when government is not open and they have been harmed by someone in some way and want some measure of justice for that, and they show up on the weekend. And so I guess that's my question. So today, how does this differ today versus what we're doing here? And what remaining options do they have to protect themselves? Because it seems to me that we're removing one option in this scenario, or at least we're not removing it. We're kicking it to someone who may or may not act.
Right.
May or may not act in the specified window. And so if I'm concerned for my safety, today, I could get an arrest warrant issued as to someone. No.
So today, today.
Today, yes.
If you were concerned for your safety, you have a few options. You could call the police can issue can make an arrest, a warrantless arrest. Or you can go to the commissioner, and the commissioner, if there is probable cause, could issue an arrest warrant. That's today.
And again, I'm speaking as to something that happened yesterday. Like this thing happened yesterday, here I'm before you. They might issue an arrest warrant, but it would depend on whether, it would or would not depend on.
Well, probable cause would still be the factor. They would still use probable cause. And they would determine whether or not there is, to believe that the defendant poses a danger to another person or to the community. That's the standard that's already law, that they would already have to follow.
Got it. And so tomorrow, if we pass this law, what's going to happen instead is they'll go, the incident happened, they come in, they make the complaint, and it goes to the state's attorney. But will they be under an obligation to respond in a timely manner?
So what happens is that after this, if this bill were to pass today and then tomorrow they came in, they would come, if they came into the commissioner, still have the option of course, of always calling the police. If they come into the commissioner, upon finding probable cause, can issue a summons. That summons could later be served would be served on the person unless the state's attorney either decides, you know what, I'm going to file a motion to convert this to an arrest warrant. Hold on 1 second. Yeah, so I'm at B. I'm on page 3 of section 2607.1B. So if they receive the summons, they are going to, they meaning the state's attorney, they're going to review the case and as soon as possible, but no longer than 72 hours, to determine whether or not they need to request a judge to issue an arrest warrant.
Got it. And sorry if this sounds if I sound like an idiot, I'm just actually trying to have this all articulated also, so we all hear what's going on here. And so do we have reason to believe, or do we know that the state's attorneys can respond within this window?
They came in with 72 hours.
Okay, so
That's what they came in with, yeah.
and do we have, and I guess this was a question that was, or a fact that was alleged when we last met earlier today, but, you know, what percentage of cases where an arrest warrant is issued, is it not taken up within 72 hours? In other words, are we shortening or not shortening, you know, how much time may occur? This is not an area of law that I am familiar, you know, I'm not a practitioner of this. So on the ground, I just don't know, are we creating a window of opportunity for harm versus today? Does that make sense? Well, someone had suggested that today, people aren't, even if there's an arrest warrant, they're not getting arrested immediately anyway. In other words, if we create this review period, we're not creating any additional harm if today nobody's getting arrested within that window anyway.
I think to say nobody's getting arrested in that particular time frame would be an overstatement.
So somebody is.
To say that most are not, based on the information that was shared with us, would probably be more accurate. So
Okay.
most warrants for arrest are not effectuated within the 72-hour time frame. That's the information.
So can we
that
just kick the
received.
tires then on someone who legitimately thinks not only did something happen yesterday, but something's going to happen tomorrow? And now you have someone who's scared in front of you. Same set of facts. They say, this thing happened yesterday. I want justice. Also, I'm a little scared that they're going to come by my place and do something. So again, just to be clear, we believe for many cases, there's no additional harm because no one's getting arrested within that window. But I guess you're suggesting that there are some handful of these cases where someone might be in harm and could be arrested. In fact, there might be some arrests that are warranted in that instance. What's our theory of the case for that set of cases if we pass this bill?
So I think on that set of cases, now we have to weigh, and it's a challenging thing, but we have to weigh. I also shared some statistics where there were 1,174 individuals who were arrested or a warrant was issued, right, for whom no case was actually, there was no determination in the case. The case was either null pros or dismissed. And so now we really are weighing, right? Is it, you could consider those victims, because I've had a case raised against me where it was null pros, but I've had to go through this process because I had a warrant issued for me, right? Versus another set. The issue that I've been challenged with is that we don't leave those individuals without an option. We may not like the option, some people don't like the option, but they can go to the police and they can file a complaint directly with the police and have the police follow up and do whatever investigation. And the police could make an arrest without a warrant. Or the police could seek a warrant with the commissioner as well. So there is an option. We have not left individuals without an option. That would be my point to you.
Yeah, and so sorry, so your options would be, well, you go through this and hope this thing plays out. You have a police angle, and there is, for some people, there's the whole TPO
Correct.
angle, right?
Correct.
Okay, all right.
Delegate Ericon.
Thank you, Madam Chair. Just for the majority leader's edification on this 72-hour thing, we did discuss in subcommittee the 72-hour issue, and it was brought up that it would need to be clarified when the 72 hours begins, whether it begins when the person filed or whether it begins when the state's attorney's office was alerted to the filing. So I don't see anywhere in there where it addresses that particular problem.
We, look on page 3, at section B, and it says on receipt of a summons. That's our starting clock.
Okay, so it is when they get it,
Yeah.
so, okay, so how long could a victim potentially be waiting before they have that issue addressed?
Whether, how long they could be waiting is 72 hours.
On
No, but she said how
receipt of a
long.
summons, on receipt of a summons. But how quickly will the summons be issued after the application?
The summons can be issued immediately while they're there.
Okay.
Yeah.
And is it, or does it have
No,
to be?
no, that's why, if they go to a commissioner, they're going into a commissioner, this is an individual, and the commissioner, they walk away with the summons being issued.
Okay.
Now, the other thing is that, of course, the summons hasn't necessarily been served immediately, but it is issued immediately.
Okay. And then they have 72 hours to determine whether or not,
The state's attorneys, have 72 hours to determine whether or not to request, they're not making the determination, got to be clear on that for separation of powers, but they are going to ask the district court to issue an arrest.
and that shifts it to an arrest warrant from a summons?
That's correct, or motion.
And the summons can be issued without the arrest warrant process? I'm
Yes, the
okay.
summons literally is just calling you into court.
Right, okay. So
The
that's,
arrest
gonna-
warrant
that's,
is hauling
that's,
you.
that's either way, no matter what happens, there's going to be a summons issued. And then it's going to go to district court judge, and they're going to decide, or a judge of the circuit court, and decide if they should also issue an arrest warrant.
Right, well, essentially what they would be doing is vacating the summons and issuing arrest warrant.
Okay, that helps, thank you.
Are there any other questions? And take your time to mull it over. Delegate McComas.
I have a question. I don't know too much about search warrants or anything like that, or when the police will go to a judge to get a search warrant, and there is a judicial officer, a judge who is on duty to get those, and they'll go to their house or whatever. And so I kind of defer to Delegate Phillips here on this. What is the standard for a search warrant as opposed to a probable cause? I mean, are they
You mean an arrest warrant?
No, a search warrant, because a search warrant, there's somebody on duty that can, a judicial officer that will give the police a search warrant when they want it, when they need it. I think that's correct.
I'm not sure about that.
Delegate McComas, I think the standard is probable cause. So because otherwise, I mean, the Constitution says no unreasonable searches, and then probable cause gives, and you can do a warrantless arrest, but probable cause allows you to do, warrantless search, but probable cause gives you the ability to get a search warrant.
Okay. And so we don't feel that a commissioner, which we've done for years and years, can determine probable cause if someone comes before the commissioner, and it's a serious situation.
Yeah, so the problem is, and you're absolutely right. So here's the thing. I am going to say on behalf of the committee, I don't think it's so much the competency of the commissioner, even though that was a great deal of discussion in the hearing. I don't want to attack the commissioners. I did send out to you all the training that they have, and it is extensive. These commissioners do not have law degrees, this is true, but they do have a bachelor's degree, it is required, and they do have extensive training, and they train on probable cause. With that said, however, the problem that the bill is trying to fix is individuals who can come to a commissioner and say, my neighbor Johnny did whatever, right? And if they find probable cause, Johnny will now be arrested. And that is problematic for someone to be, that is problematic to be arrested without, it's problematic for someone to be arrested and and it hasn't been determined as to the truth of the matter. So that's the crux of what we're trying to get to.
Okay, so what I'm kind of asking, though, is, okay, the commissioner...
Can you talk a little bit closer to your microphone?
Oh, I'm sorry. The commissioner has an opportunity to at least see the person, the applicant that comes to him. And the applicant usually will write out, unless they can't read and write, and then the commissioner will do that to fill out the form. My thing is that the state's attorney is not going to have that ability, because the commissioner will say, this is the situation, but that state's attorney is not going to be able to look the complainant in the eye and kind of feel for him up or down. Now, I realize that, you can always sell swampland in Florida, but the bottom line is that personal interaction is very, very important, I think. And I realize I've got, I sort of have a background in that because I was a commissioner, and I think it makes a big difference. And I think that's being blocked in a sense, and also the exigent circumstances, because some of these cases, if it's domestic, and we can go back to Judge Wilkinson, because that was a good example of a situation that went horribly wrong, and he probably would have killed his family too. Instead he killed himself, which is good, the bad guy. But I just think that domestic, if there's stuff going on, it can end up to be a real tragedy. And I personally think we could find a better way to deal with these false accusations, which are a pain, but I don't think you can compare a tragedy and somebody getting killed on the other side because of false claims. We should be dealing with false claims, not taking away that personal interaction. And if there's a real concern, that they can immediately issue a warrant.
Right, and I appreciate that. And in fact, during the break, I was talking to someone about false claims, and the 2027 bill, we were talking about that, because that itself is an issue as well. This bill has become the closest thing we can do to a compromise on both interests, the interests of the accused as well as the interests of the victim. The protection that the victim still has is the police officer, who can issue an arrest warrant. So we still have that protection doesn't go away. The other protection is that the summons is getting reviewed by the state's attorney as well. So that's kind of helping with that false statement part. So and this is one thing I tell people all the time with this committee, it is always a balance. It's a balance of interest in this committee, and I hate it, but that is what we have to do. Delegate McComas, and then I'll go to you, Delegate Carter.
I think my counter argument to that is there are some people that are very fearful of the police. And there are some police that, they come in with all that stuff and they're kind of rough and gruff. And you have somebody that's fearful as they are, and then let's say you throw in a different racial background, and, we all remember George Floyd and all that. I personally think I don't think it's as broke as we all think it is. And I think what we should be focusing on is the issue of the folks making false claims and figure out a way to handle that. But I don't think we should take away that personal interaction with the commissioner and the applicant.
Thank you, Delegate McComas. Delegate Cardin.
Thank you, Madam Chair. I very much appreciate this discussion. So I step back to the fundamental question is on unsubstantiated allegations, should somebody be arrested or should they be summoned? And that's really kind of where we're going here. And I'll say again, and I have personal experience with many times, sometimes people being honest and sometimes people being dishonest when they go to the commissioner and they just want they want to do it for good reasons, and some people want to do it for bad reasons. And we have to figure out a way to reform the system that doesn't reduce people's rights. And I think that you have done an amazing job, Madam Chair, of trying to figure that out, even though there's going to be, there's going to be some winners and some losers. If you're afraid to go to the police, I would argue you now can still, if this bill passes, you can still go to the commissioner. You can ask the commissioner for an arrest warrant. The commissioner immediately, upon issuing a summons, that summons immediately goes to the state's attorney. You can then go requisition the state's attorney to look at this issue very quickly, get them to ask for it to be converted into an arrest warrant, and probably get that done quickly. If in fact we are talking, as Delegate Moon said, about, or questioned about whether this is all happening in real time, or whether it's happening over a course of hours or days, the truth of the matter is this doesn't reduce people's rights the way that it's drafted here. If it's taking 72 hours, then there's no difference as to whether this arrest warrant is going to be, because as soon as it's converted, they've already started the process of getting the summons served. All they have to do is, instead of doing the summons, now they're doing the arrest warrant. So I think that that's a really great way of making sure that that we're not reducing people's time to get some relief. And then the issue of, again, being issued versus served, I think that the question was answered that, yes, it's issued immediately. It goes, the recommendation or the case goes to the state's attorney's office, and they will have to figure out a way to effectively do this and try and do it quickly. And the only issue you have is if it goes to the commissioner sometime when the state's attorneys don't have the ability to review, maybe in the middle of the night. So it may take a few hours for somebody to come and review this, but presumably they're going to do it faster than 72 hours. And the last thing I will suggest, as I feel very comfortable voting for this legislation, is that about a generation ago, it was actually, I think for the 1 or 2 years I wasn't here, we were doing a lot of, no, maybe before I left, bail review reform. And this is, even though it's a different sort of issue, it's the same concept of we want to make sure that we are not putting people, incarcerating people improperly. And what the Maryland has come to, and it seems to be working pretty well, is that the least restrictive best practices are being used to make sure that the fewest people are incarcerated. And the only things that you look at is, are they a clear and present danger to the community, or are they a fear of flight? And those are the only two things that a judge looks at, and a judge figures out how to best, and even if they are, they figure out what is the spectrum they use. So sometimes they'll use home monitoring, sometimes they'll be incarcerated, sometimes they'll be on their own recognizance, sometimes there'll be some sort of bail that'll be imposed. And here, I would think that on unsubstantiated allegations, a summons and a fear, if you don't do what this summons tells you, you can't. The summons, by the way, they're going to say to them, you can't hurt this person, you can't see this person, and then they're also going to, by the way, if there's a TPO that's involved in this, that's going to happen probably within 72 hours, but probably a lot sooner than that. You're probably going to get, your TPO can oftentimes happen the same day. If you go in really early in the morning, you may get it at 8 o'clock or 8:30 that morning, the TPO, in which time you're going to have the stayaways that are going to be required. And if they violate that, you can be assured that that summons is going to be converted into an arrest warrant. So I think that this is a very good compromise. It's not perfect. Maybe it should go a little further, maybe it shouldn't, but I feel comfortable. Thank you. I appreciate you giving me the time to say that.
Sure. The Vice Chair. And then I'll come to you, Doc.
Thank you, Madam Chair. Great work. I know we've been going back and forth and toying with this, and I feel that we have struck a good balance. And it bothers me a little bit when we speak of victims, because we heard from lots of victims here at this hearing. People who aren't able to travel out of the country because somebody filed a false claim against them. So we heard from lots of victims. This warrant can lead to deportation. We know that. So I like to use the word proponent and respondent, or either plaintiff or defendant, because it hasn't been decided at the time that we're asking for warrants to be issued. Now, it hasn't been decided. So I think it's really important to make sure that we understand that this is a balanced approach to dealing with all victims and prospective victims, proponents and respondents. So I'm really excited about that. Madam Chair and I have been talking just a little bit about expungements and how to get it off your records. We think that that might be automatic under Moon's bill coming up soon. Was there something else? But it is really important, and I want to congratulate everyone who had something to do with this for striking a balance. Thank you, Madam Chair.
Delegate Phillips?
The Vice Chair just addressed one of the issues that I want to make sure we're really clear on. When a person comes in, they are the complainant. The other individual is then, once the state issues the warrant, is the defendant. We've been using the word victim as the person that comes in and makes the charge, and that may or may not be the case. So I just want to be really clear on that. And Madam Chair, if we could add one other component to the reporting, which would be summons, so we can really see what's happening with these cases as they go through.
Okay, tell me directly what you mean by summons.
So,
So you want to know how many summons are issued?
yeah,
the
we want the
Commissioner?
data not only for each arrest warrant issued, but also for each summons issued. We should be able to get that same data.
And that, okay, and that would be on the race, sex, age of the victims, and by the race. Okay, so let me just explain a couple of things that we can and we cannot do. And what we cannot do is get the information on the victims,
Understood.
okay? So I do have to strike that
That would
section.
be the proponent, right?
The language that's in the
The
bill,
complainant.
the language that's in the bill is victim. I cannot get the information of the complainant, okay?
Yep.
And also keep in mind that any of the respondents or defendants are self-reporting. So the information we get would be them self-reporting as to sex, age, race. That's their self-reporting. Just keep that in mind, okay? No. This is on the defendant, because we're asking for information on the defendant now in the bill. So what I'm saying is, I just want everyone to know that that is self-reported. Okay?
But the complainant usually, doesn't that complainant has to identify, the complainant identifies,
So it may not be accurate.
it may
It
not
may not be accurate. That's my whole point.
Okay,
That's the
I get
only
it.
point I want to make.
I got
It may
it.
not be accurate.
Understood.
Okay?
Understood.
So we have to just keep that in mind. The other change I have to make on, since we're doing a couple of changes now, on Section D, I have to change that from whether an arrest warrant has been issued to whether charges have been issued in response to an application for a statement of charges filed by the victim. That's just some technical stuff we got to change. Okay.
Absolutely, yep.
Hold on one second. Get to Delegate Taylor.
Thank you, Madam Chair. I'm looking at the reprint, and I'm not seeing any reference to the commissioner only being involved when the court's not in session.
Oh, good question.
Did we take that out?
Yes, we took that out. Yes, we took that out. So now it's not a matter of open or closed. It's just a matter of who's issuing what. So we have, or who's, where it originates, not so much who's issuing it, whether or not it originates from the police, from the state's attorney, or from an individual. So that's only the issue now. And if the charges are initiating, or the complaint is initiating by an individual, then the commissioner would issue a summons. If the charge is originating by a police officer or a state's attorney, then the commissioner would issue an arrest if that's what they're requesting.
Thank you. So for the complainant, what we heard during the hearing was quite often these folks are serial complainants. And I wonder if our report should also capture somehow how often this person has been here and made a complaint about a certain person, knowing that in some cases they may have made a complaint multiple times and maybe did not press charges ultimately because they were afraid or whatever. But we heard very distinctly from our panelists that there was harm done to those individuals because there were folks out there complaining against them all the time, which ruined their life pretty much. So I wonder if there's some way, even if we can't prove that they have issued a false statement, but at least track the fact that, hey, this person's been here 15 times in the last 2 months. What I am fearful of now is that now they will learn not only to go to the commissioner, but they may also go to the police. So if one hand is not talking to the other, in other words, I'll go to the police next time. I'll go to the commissioner. I'm just making sure that information on that. I'm just hoping that information on that complainant is tracked somehow and not, as something negative against them, unless there's some reason to believe that that should be negative.
So I will say, Delegate Taylor, I appreciate that concern. The courts do not track or provide information with respect to claimants in the aggregate, okay? Now, if we ever have a bill hearing on getting to the heart of the matter, what Delegate McComas was talking about, and that is false statements. Mm-hmm. If we have that hearing next year or some year in advance in the future, one of the things that we could ask if anyone comes in is, such as a state's attorney or someone else, how often can you give us data on how often you're finding, or even if it's anecdotal data, how often are you finding that individuals are repeatedly filing complaints? So that's the way we would have to do it for now.
I love that. I'm sorry to interrupt because I know we're running out of time, but this bill was originally named false statements. So why do we believe if we come back next year or the year after that we're going to get any different result from a bill called false statements when right now we have one and we cannot get that information from the complainant from the judiciary. We cannot get that information. The complainant information is not subject to the information that we can obtain. Do you think that
what is available, it is on, case search to some degree, and, there's that, but not in the aggregate, as in, what we might be able to get is how many multiple cases, how about that? How many multiple cases have been filed? Something of that sort. We could get that.
And just a quick question, if somebody gets a summons now and doesn't act on it, because they're like, I didn't do anything, why would I act on the summons? Like,
Right.
well, I'm not going in there because I didn't do anything.
Right.
What happens if they don't
Then
act on the
a
summons?
warrant can be issued for them. Then a warrant could be issued for them. And that's in the bill on, that's current language. On page 2 of 3, line 31, the defendant previously, a district court commissioner may issue an arrest warrant only on a finding that the defendant previously failed to respond to a summons that had been personally served or a citation. And then there's some more instances where they can issue an arrest warrant. Delegate Simpson.
Yes, as our chair has said, this is, a balance of perspectives. And since I don't sit next to Delegate Valentine, I would like to hear his perspective when it comes to law enforcement.
Delegate Valentine, would you like to give your perspective when it comes to law enforcement?
Absolutely, Madam Chair. To answer the good delegate's question from earlier, how would this change from today to tomorrow? Should we put this in? I think so many of the safeguards are still there. For your domestic folks, you would have as we've touched on, the temporary protective orders. For non-domestic related, you would have the peace order processes. I think one thing that we sometimes forget about in this process is if an arrest warrant is, we've talked about whether one is issued, we talk about how long it takes to serve, but these folks aren't staying in custody. I mean, so often, more often than not, just because they're arrested, they could literally be out the door within an hour. So there's a physical arrest, yes, but they're not going to be held for days at a time when we talk about the safety component. So I want everybody to know I made many a domestic violence arrests, and those folks were released prior to me being finished with the paperwork. So they're not a summons. You're still going to be charged with a crime. You're still going to be charged. You still have a court date. You still have these other aspects and other avenues. I'm concerned about people being arrested that, that shouldn't have been arrested. So many of the folks came in here to testify. So that's my take on this legislation.
Delegate Embry.
I wasn't going to say anything because I didn't think we were making any changes, but if we are tweaking, can I suggest instead of referring the summons, we refer the application for statement of charges, because the summons is just the notice to show up in court, and we want the state's attorney's office to review the charging document.
Okay, so are you speaking, can you tell me specifically?
Yes. So A3 on page 3 of 3 shall refer a summons issued. We could say summons, they can get the summons, but what's important is that they get the application for statement of charges or the statement of charges that's been issued. I think either one, but it's not the summons that they're reviewing.
So wait, the summons was issued.
Right.
Right.
Shall refer, so what the state's attorney's office would review is not the summons.
They're reviewing the statement of
The
charges.
statement of charges.
Okay.
That's all. And then if I could just, in terms of my opinion, I've expressed concerns and I still have them, but I will say that the data from the Baltimore City office, the high rate of null, well over 90% of these cases resulting in a null process. While that's not conclusive about whether or not a crime occurred, it does, I think, lead anyone to have some concerns about the process. So that was very helpful for me in this deciding how to handle this. So thank you.
All righty. Delegate McComas.
One thing that happens, like in domestic violence, you know who the perpetrator is on case search, but you don't know who the victim is. And I think that may be the same way with peace orders, and perhaps even, well, I don't know if it's like an assault, and it's a criminal summons or charge, but the point is maybe they need to keep track of who the complainant is on all of those, and it's an internal thing, but the commissioners can look them up. And they can see, okay, Susan McComas has been there, 100 times upset with her husband, or something like that. So that would be very helpful for them to gauge what's happening and also for the police and the state's attorney's office. So obviously it's going to cost money because it means, fixing the computers and everything. But I think that would be the best way to find out if somebody's really, harassing and harming the neighbors and filing a lot of stuff and it never gets resolved.
Okay, so let's on the bill as amended, as on the amendments, one thing that we do say here, and I want to say this out loud because this may be addressing what Delegate Taylor said and what Delegate McComas just said, at 2607.2, on page 3 of 3, on the reporting, this is the reporting information. We say that we want this information, but we also say the number of applications for a statement of charges filed, this is one of the things we want, including whether the application was filed by the police, state's attorney, or an individual. And for each type of applicant, meaning complainant, whether the application was denied, resulted in the issuance of a summons, or resulted in the issuance of an arrest warrant. So what we could say here is, because we are going to find out the number of the applications that were filed. We will have that information. But it sounds to me like what we want to know in addition is how many multiple applications are filed. I'm not quite sure how to word that, but it sounds like that's what you're saying. Okay.
That's one last thing.
Sure, and that'll give me time to confer with counsel.
March 1st, 2027. Could we escalate that time frame for which this report could be generated? Could we make this an emergency bill? We've already asked for this information, right? We've already asked for it. They're purportedly preparing it, right? We've asked for a lot of this information already. Why are we waiting until March of 2027 to get this information? In fact, if we don't get it until March 1st of 2027, we won't have it in time for our bill hearing for the bill that we're purporting to generate for 2027. So I think we need to change the date. Thank you.
Right. Okay. I understand. So a couple of things. Some of this is not currently being tracked, okay? And in fact, they meaning the district court, is going to try to create the tracking mechanism based on what we end up passing out of the, not create, but tweak the tracking based on what we have. So that's one thing. And so we need to give them time to be able to do that and to be able to program that. The other thing is that an emergency bill would be effective at the time of the signing. And I think that there is a little bit of one, education as to what the law is going to be that needs to go out for both the complainant as well as the respondent, and this would allow time for them to do that. Now, mind you, this becomes effective October 1, so it's not, it's not a December or some other long-term deadline, but this is an October 1 deadline.
You think we'll have the information in time for next year's bill?
Oh, and that's the other thing, they also need to change their forms. I'm sorry, Delegate Taylor.
Yeah, next year's bill, we were thinking about doing something for 2027 to deal with false statements, et cetera, et cetera. If we need the information that's on this report, we're not going to get it until.
Now, with that said, what I am able to do is ask for information. So if we find that the judiciary has set up the tracking mechanism and they've got it, then we can always ask for that data and we can have a bill hearing based on, just like we did with the data that Delegate Embry and Delegate Phillips asked for. We can always ask for the data, have it available. It might not be in a pretty shiny report, but it'll at least be available to us. Okay. Is there a second? Second. Okay. All in favor of the amendment, please raise your hand. Yep, okay. It is not unanimous. All opposed, please raise your hand. Okay. All right. On the bill as amended.
Second.
Okay, there's a motion favorable as amended. Are there any other questions or concerns or thoughts that people want to share? All right. I'm hesitating on purpose. All right, seeing none, please call the roll.
House Bill 336, Delegate Addison, Criminal Procedure, District Court Commissioners, and False Statements. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin.
Yes, and kudos to Delegate Phillips.
Delegate Cardin votes aye and gives kudos to the Criminal Law Committee Subcommittee Chair. Delegate Congolo. Delegate Congolo votes aye. Delegate Phillips, I skipped you. I skipped you talking about you, and I apologize. Delegate Phillips, please.
Yes.
Delegate Phillips votes aye.
Real quick.
Yes.
I want to thank everyone for this discussion. This has been a very challenging issue. And as I said before, one of our jobs is to kind of weigh the challenges. And unfortunately, sometimes not everybody's going to get exactly what they want. And I think this bill is a real compromise, and clearly not everybody got what they want, but I think it's a step in the right direction. So thank you.
For the record, Delegate Phillips voted in the affirmative. Delegate Congolo voted in the affirmative. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons.
Yes,
Delegate Simmons votes aye and would like to add. Delegate Boucher is absent. Delegate McComas.
I realize a lot of work has been into this, and I hope no one gets hurt, and I vote aye.
Delegate McComas votes aye. Delegate Moreno.
Yes, and can I explain my vote?
Yes.
Okay.
Turn on your microphone.
Is it on?
Yep.
Okay, so I hope that this bill solves the problem that it seeks to solve. As a board member on a nonprofit that addresses intimate partner violence and domestic violence, I hope that this bill does not hurt those individuals. But I vote yes.
Delegate Moreno votes aye. Delegate Aracon.
No.
Delegate Aracon votes no. Delegate Taylor.
I vote aye. I'd like to explain my vote. Yeah, I am just amazed at the amount of work that's gone into this, and there's been a lot of work that's gone into this bill. This is not the first time we've heard this bill, and to get to this point is some progress. I'm just not sure that we're addressing what we intended to address based upon the hearing and the people that continue to come to say they're being victimized by someone who is charging them with false claims. And, you know, I'm voting yes. I'm very happy to see that we're going to get, hopefully, reports that may help us, give us the ammunition that we'll need to pass a bill that will really address what we're trying to get at in 2027 or 2028. So thank you, Delegate Chair Criminal. Appreciate it. And I vote aye.
Delegate Taylor votes aye. Delegate Simpson.
Favorable with the amendment. Oh, I add.
Oh, for the record, Delegate Taylor would like to add. Delegate Simpson votes in the affirmative. Delegate Mangione. Yes. Delegate Mangione votes aye. Delegate Moon. Aye. Delegate Moon votes aye. I'm sorry, what was that last part? Yes. Just aye? Okay. Fantastic. Delegate Conaway. Yes. Delegate Conaway votes yes and an add. Delegate Woods. Yes. Delegate Woods votes aye. Delegate Williams is excused. The tally is 16-1-0-1-1. Oh, the Vice Chair would like to add on to the legislation. Delegate Cardin would like to add on to the legislation. Is there anyone else? Delegate Moreno will add on to the legislation. Delegate Moon adds on to the legislation, as well as Delegate Woods. And Delegate Phillips is already on the legislation. Again, the tally is 16-1-0-1-1. The motion carries.